and 265158. The record reflects that Mr. Yoder is present here in the courtroom today, and if I could have counsel to your hands.
Brian Ziegler, on behalf of the people, Your Honor.
Tom Seeger appearing with on behalf of Mr. Yoder.
This is the date set for sentencing in this matter. Mr. Yoder, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Oh, yeah.
Mr. Seeger, are there any additions, deletions, or corrections?
You're not here.
Are there any challenges to the scoring of the guidelines?
You're not.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation today?
Your Honor, I would support the recommendations contained in the PSI. Mr. Yoder is a relatively young man. He has minimal criminal history. It seems like he's fallen into some issues with both drinking and substances. He has an opportunity at this time to turn his life around, to take advantage of this opportunity for 74 probation. If the court is willing to extend it, I sincerely hope that the court does, and I sincerely hope that he takes advantage of it.
Thank you, Mr. Seeger.
Likewise, I would just ask the court to follow the recommendation, and I agree with Mr. Ziegler, and that's part and parcel of the reason why I had offered him the ability to plea under 7411, because he is a young person. Because albeit he does have some prior criminal history, he does not have a long, extensive criminal history, so hopefully he's capable of rehabilitation. He's expressed to me his want to make better decisions. Clearly going forward, he needs to make better decisions. If given the opportunity at 7411, it is very much an opportunity for him to exonerate himself in some ways. And so I think that that's a great opportunity for him. I would just ask the court to consider doing that. Would know that he indicated that he successfully followed through with that probation. It did in the recommendation recommend a period of 3 years, which I don't know if the court finds that to be a necessary time period. I'm not saying that you want to benefit from a probationary term, Your Honor, but 3 years for a possession term seems relatively long, albeit he is receiving the benefit of a deferral status. But if the court was going to place him under probation under 7411, if the court thinks that 3 years is appropriate, I would ask the court to consider a period of maybe 18 months, which would probably be somewhat of a standard probationary term for a similar situation. But if the court feels otherwise, it's recommended that that's necessary.
Mr. Yoder, was there anything you wanted to say today?
No.
All right, I did read through the pre-sentence report, so I'm familiar with what happened in each of these cases. And there's also a lot of information in that report about your background and your circumstances. I take all of that into consideration along with what the lawyers had to say here today. I do think the recommendation is generally appropriate through probation. Miss Wagner, this isn't a case where he's automatically not eligible for early discharge, is that right?
No, he would be considered for an early discharge.
So, your behavior certainly in the impaired driving case is concerning. It's frankly, as somebody who's out driving, it's frightening that somebody in your condition was out in control of the vehicle at that time, the way the police officers found you. And so I think probation is absolutely appropriate to monitor you, to make sure that you're getting treatment if you need it, to monitor your drug and alcohol abuse and use as well. And I also think, based on your lack of significant prior history, that the 7411 statute is appropriate as well, to give you an opportunity to be successful, to be discharged and not have this be on your record, which is going to be a big benefit for someone at your age. And if you're not successful, then we'll be back and there'll be additional penalties. However, it's my hope, and I'm sure everyone else's, that you are successful on this probation. I am going to impose the term as recommended. As we just indicated, you would be eligible, if you fully comply, to be discharged quite a bit earlier than that. So that's hopefully another motivation for you to comply with your probation, to get out from underneath those requirements as soon as possible. I'm going to impose some jail time. I'm going to hold that in abeyance. Again, I'm hoping that that's going to be an additional motivation for you to comply with probation. If you do, then you would never have to serve that jail time. If you don't, then I can impose any or all of it immediately without any hearings, nothing, just go right to jail. So the court is going to, on file number 244973, which is the impaired driving, sentence you to 53 days in jail with credit for 53 days served, a crime victim's assessment of $75, a DNA testing fee of $60, and a $53 state cost. On the possession of methamphetamine charge, the court is going to order that you be placed on probation pursuant to 7411 for a period of 36 months. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. So it's really important that you go through those with your agent so that you know what you're going to be required to do. The court is going to order that you serve 6 months in the Belcasty County Jail with credit for 53 days served. Again, I'm going to hold that time in abeyance. A crime victim's assessment of $130, court cost of $325, attorney fees of $350. I'm not going to impose an additional DNA testing fee on that file. The $68 state cost and a supervision fee while you're on probation of $30 per month. Because this is pursuant to 7411, there is no ability to appeal the sentence on the methamphetamine charge. You can appeal the operating while impaired charge or seek to appeal it. If you wanted to try to appeal the sentence in that case, you would need to file that paperwork within the next 21 days. If you have more questions about that, Mr. Seeger will be able to help us. Mr. Seeger, is there anything further we need to address today?
There you go.
Ms. Wagner, do you want Mr. Yoder, because I'm assuming he's going to be released today based on the court sentence. Do you need him to check in today, or how do you want him to make contact?
If he can report tomorrow to the Kalkaska office before 12 p.m., thank you.
Okay, so Mr. Yoder, just make sure you do that, all right? Do you have any questions at all? Thank you. Good luck to you going forward. All right, do we have Miss Brister back there? Out or is she lodged?
I talked to her, she's right here.
Okay. Ms. Brister, if you can come right up to the podium, please. We're on the record at Poe versus Brandy Brister, file number 255018. Ms. Brister is present here in the courtroom today. All right, so this is set for a probation violation hearing today. I did get an email from Ms. Wagner with some recommendations if she pleads guilty. Mr. Seeger, have you seen that?
I have, Your Honor, and it is her intention to accept responsibility.
She's going to plead to the one non-technical violation. Is that correct?
Correct, Your Honor.
So, Ms. Brister, have you had an opportunity to speak with Mr. Seeger about this? And is that how you wanted to proceed today?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? Thank you. Ms. Brister, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes, sir.
And you understand that by pleading guilty, you're going to be giving up that right? All right. And you understand that what Ms. Wagner is recommending and what I'm likely to follow is that the court would impose that jail time that was previously held in abeyance. You would have credit for 45 days. And then otherwise you would just be discharged from your probation. With that potential penalty in mind, Did you want to enter a guilty plea today?
Yes.
Okay. Has anybody threatened you with anything to do that, to get you to do that?
No.
Has anybody promised you anything other than what we've already discussed here on the record? Okay. And is it your own free choice to enter this plea? Back on June 26th of 2025, were you on probation here in Kalkaska County?
Yes, I was.
And were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances?
Yes.
And did you have possession of methamphetamine at that time?
Yes, I did.
And was that a substance that was prescribed, or did you have any other legal right to use that?
No, sir.
All right, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged at count 1 of the non-technical violation. The court will accept your guilty plea. Other than what was in your email, Ms. Wagner, was there anything else that you wanted to state prior to sentencing?
No, Your Honor, thank you.
Mr. Seeger, did we want to proceed with sentencing today?
Your Honor, I guess that part of the reason why we were hoping to proceed with sentencing, as much as that she set for sentencing and do it tomorrow. And so like if there was jail time that was imposed, they would run concurrent to the other file to the extent that Judge Hunter imposes some kind of jail time. So to that end, Your Honor, I would have no objection to sentencing. However, Your Honor, she did have a letter that she wished to provide to the court in advance of sentencing, if it's willing to review it.
Certainly. Can you do that? Did you want this attached to her file?
Your Honor, if I could only have it back, and as much as I assume the judge would need us to review it tomorrow.
Okay. Is there anything on behalf of Ms. Brewster today?
Your Honor, on behalf of Ms. Brisker, I can honestly say that I have many clients who are somewhat similarly situated, and many of those clients continue to have substance abuse problems for which they have relapses, and there are a lot of different reasons why they have those relapses. But Ms. Brisker has not tried to pretend like she doesn't have a problem. She hasn't tried to blame it on anyone else. She hasn't tried to come up with ordinary excuses of it wasn't mine, or I had nothing to do with it, or I had no responsibility for what had happened. She's probably in the 1% of people who fall within the same domain for which they're being charged, who have actually accepted responsibility for what they've done, and they've also wanted to address their underlying substance abuse problem. She clearly does have a problem that needs to be addressed. It will either be addressed through her other file, or it will be addressed through this file, or a combination of both. I don't know as if jail time is entirely helpful to her, in as much as I do recognize that jail time may be a feature of pleading guilty to a probation violation and or being in trouble for drugs in general. But she is currently working, and what historically I've found, Your Honor, is that when people are struggling with substance abuse problems, it's usually in part due to perhaps economic circumstance. The letter that she provided to the court somewhat indicates that she's a very good employee, that they're short-staffed at her current location, that even if she were to receive jail, that they would contemplate giving her her job back at a later date if that were possible. But she is a valued employee. And so I do recognize, Your Honor, that there is a penalty for everything that we do. And people sometimes accept it and sometimes they don't. Ms. Brister has been very accepting of what she's done and why she needs to accept it. I guess the only thing that I can ask on her behalf is that I do understand that the jail time at one point in time was held in abeyance. But if the court was willing to defer to whatever sentence it is that Judge Hunter gives tomorrow, that would be helpful in terms of whether or not she can maintain her employment. It sounds like she's maybe turned a corner for herself. I don't want to dislodge her from having employment. I don't want to dislodge anyone from having employment generally, because I feel like a lot of the times the larger problems people have are based on not having a lot of hope for the future. And I don't make $15 an hour, Your Honor, so I don't know what it's like to live on $15 an hour. It's been a long time since I've been in that situation, but I do remember working as hard as I could to make those types of money. But it wouldn't have been enough for me to survive in any meaningful way. And even if I could pay my bills, there's no way for me to get ahead, or for me to save, or for me to invest, or for me to ultimately retire, which is unfortunate for everyone. So I understand why she may have reverted back to having a substance abuse problem. But now that she does have meaningful employment, I think that that's a good reason for her to continue on her trajectory. I don't know exactly what Judge Hunter will do tomorrow, but I'm hopeful Judge Hunter will give her an opportunity to perhaps remediate some of the decisions that she's made in the past. And again, Your Honor, she's remorseful for what she's done, and remorseful might not be the right wording, Your Honor. I think she's recognizing that she's an older person and she can't continue to have this life trajectory. And I think through counseling, through maintaining employment, through maintaining standard housing, those things perhaps ameliorate some of the problems that led her to the position that she's in today. But again, Your Honor, if the court sees fit to give her jail time, she's not arguing with it, Your Honor. She recognizes that she's the one that's in the wrong, that she's the one that violated her probation. She's just asking the court for an additional opportunity with the hopes that she's able to straighten out her life, and also that she doesn't lose her employment, which I think has been a valuable vehicle to her in terms of maintaining her sobriety.
Thank you, Ms. Brister. Anything you wanted to say to that?
I think Mr. Seeger covered. I mean, he did a good job, because that's where I'm at right now. I know I messed up, and I'm taking accountability for it.
Well, I'm familiar with your circumstances from your case, so, and we've talked before. You know, I told you before, you seem like such a pleasant individual, and I really hate to see you back here. It's certainly not what I was hoping for. And you're one of those people, maybe the lawyers feel this way too. I'm hoping that you get some help with this and that you're able to overcome it. I know it's a difficult thing. I mean,
Yes.
I don't know it from personal experience, but I see it all the time, and I know it's incredibly hard to get past that once you get in the grips of it. And I understand there are relapses.
Past that, you know.
Well, I hope so too. But I'm in the position where I gave you that opportunity. I think I told you at sentencing that, you know, I was going to hold it in abeyance, and if it didn't work out, then you were going to have to serve that time. And I've got to follow what I was going to do. It's important for you so that you understand if you're in my court, you gotta figure it out. Otherwise, we're going to go the other way, and for other people to see that that's how it works too. So all that being said, you know, if Judge Hunter does something different tomorrow, I certainly would be willing to take into consideration what he does on your other case. But absent something like that, I think it's time to impose the time that I held in abeyance, and we'll go forward from there. And I hope that you're able to continue to move forward. So the court is going to order that you serve the 6 months time that was held in abeyance. You do have credit for 45 days. The court is going to order that you be discharged unsuccessfully from your probation, and that any outstanding fines and costs be preserved. You do have the ability to seek an appeal of this sentence, and we should have, let me see if we have Ms. Brister.
I did not know she was going to get some.
So we'll have those prepared. Those will be provided to you. Your time limits for seeking an appeal won't run until you actually get those. So, but that should be today or tomorrow. And then, Mr. Seeger, anything further today?
No.
All right. Ms. Brister, you are remanded to the custody of the county at this time.